Well, I wanted to thank everybody for joining us in our third installment. If you haven't had a chance to look at the other presentations, we previously did back to the basics on the Open Meetings Act and the Freedom of Information Act. And this one is geared obviously towards libraries. We had a number of different types of entities that participated in the first two, but here we have a very library specific issue. I'm focusing this section really on the confidentiality issues. As you know, the Library Privacy Act has a provision in the end that deals with internet safety. It's PA 212, which is, a system or method to prevent children from having information that's harmful to minors. So although that is part of the Library Privacy Act, that's not going to be something we discuss here. I'm happy to answer any questions about it if you would have that, but focusing here on confidentiality, particularly in today's climate where there's concern among libraries that law enforcement will visit the library again. We had the similar issue when the Patriot Act was originally introduced. And I think now, there's concern about ICE or other enforcement issues in the library. So we want to cover library privacy and those topics as well, and law enforcement. So what is covered by the Library Privacy Act? The Library Privacy Act states, and most of this is in Section 3. Section 3 of the Library Privacy Act contains most of the regulations. So when you see references to Section 3 in the PowerPoint, that's what we're talking about. Except as provided in subsection 2 of 3, so 3.2, a library record is not subject to disclosure under the Freedom of Information Act. So what it says is basically a library record cannot be subject to disclosure under the Library Privacy Act. There were fairly recent amendments that allow libraries to disclose records under certain circumstances, and that's the except as provided by subsection 2, and we're going to get into a lot of that. But the overall premise and where we start is if it's a library record as defined under the statute, it's generally not subject to disclosure under FOIA unless there's a specific provision that says otherwise. So the first instinct of everybody who gets a request for records, whether it's a FOIA request or other type of written request for records, the first instinct is, let's make sure that this is whether it's a library record, and if it is, let's see whether it can be given out. So what is included? And library record is a specifically defined term under the Michigan Library Privacy Act. And what it means is a document, record, or other method of storing information retained by a client that contains information that personally identifies a patron, including their name, address, and telephone number, and that's an or that identifies a person of having requested or obtained specific material from the library. And I've given some examples, obviously your patron database, checkout records, internet history, program sign-up sheets. And I do want to include name, date, and other contact information, because this is a frequently asked question. If law enforcement or if someone comes in and they just want to know an address from somebody, can you give them an address? The address doesn't really tell you what kind of books they're checking out, but it's important to understand that the definition of library record is not limited to the second bullet point here that specifically identifies a person having, obtained specific material for the library. It's the person that identifies the patron itself, the patron themselves. They're identifying information, name, address, and telephone number specifically. It would also include to me email address and any other identifying information. So be very careful, even if you think it seems like, well, it's not about the book, or it's not about, that they attended this program, but the Library Privacy Act definition of library record is broader than that. So what is not included? And there's 2 slides to show what's not included. The first of them is it does not include any non-identifying material that may be obtained for the purposes of studying or evaluating the circulation of library materials in general. Circulation number, total program attendance, like numbers and facts and things that you report out to the community that, you have this many programs a year and X amount of people attended them. As long as there's a name attached to it, those types of statistics and numbers are fine. I put out here, it's not really specifically non-identifying material, but employee records are not library records that are covered by the Library Privacy Act. We're talking about patron records here. Anything that's like millage information, budget, anything that's operational from the library that's not really connected to a patron would not be considered a library record under the Michigan Library Privacy Act. Now, this is a newer provision, and I think it's still one of the most common questions that I get. And I think it's actually the thing that libraries, and myself included, have a really hard time adjusting to it, because for years, okay, so up until a few years ago, my opinion was that surveillance video was included in a library record. This is before the amendment. The amendment changes it, but the reason is that it talks about how you identify a patron, name, address, and so forth. And to me, a person's face, a picture of a person would be included among that. And there was some support from other communities that had similar, other states that had similar provisions in their library privacy laws that corroborated that. And so we spent a lot of time with libraries. We had video of thefts, a video of crimes. We had things that were happening outside the library property that people wanted surveillance video for. And each time we said, look, it's a library record. We had to go through either get the court order. We had to go through a lot of hoops. And the hard part is that in a lot of the instances, it was the library itself that wanted to share the video footage. For example, nobody wants crimes to occur in the library, right? And if a book is, somebody's laptop is stolen and you can see the person who's stealing the laptop and it's on video, it's very frustrating to get a remedy for that patron whose material has been stolen, to get a remedy for them and to prevent crime in the library if you had to jump through a lot of hoops, which included a court order to give that surveillance tape to law enforcement. So with the recent amendment, and there's some caveats to it, so you have to be very careful. A library record now does not include recorded video surveillance images made solely for the purpose of security purposes that do not include images of an activity or other document or record that identifies the person as having obtained specific services, materials, or information sources from the library. So putting this all together, if you get a FOIA request or other request to view video surveillance, it is absolutely critical that you review the tape yourself, either the director or a designee of the director, to determine whether it includes any images or activity or other document or record that has identified a person as having obtained materials. So what would that look like? That would look like if you have a video on the front door and you can see patrons leaving, and if you can see titles from the book, that would be something that would have to be addressed. Similarly, if you have let's just say you have a camera that's faced on the door of your meeting room. And in the meeting room, and the door, before a session or a program, you had the title of the program, anyone who's going to X program, here's the entrance, and you can see people walking in, you can tell who they are. That is something that would show someone is obtaining a specific service from the library. So what you would do is review the video and then determine whether it's a library record or not. And we're going to get to that in a little bit and how you do that specifically with respect to surveillance. So the first step is determine whether it's a library record. So with any other type of document, that's the first step. Is it a library record or not? Are they asking for checkout material? Are they asking for a program sign-up sheet? Those are clearly library records. With video surveillance, you would have to determine whether it was a library record or not. If you review the entire videotape, and it shows no patrons using that information, any information from the library. Maybe it's a video that's pointed at your bike rack, and all you can see is patrons coming and going and locking up their bikes and not locking up their bikes. Then that would not be a library record. Similarly, if you saw a book title and were able to redact it or blur it out so that you could no longer connect that specific material to the person, then that would no longer be a library record that could be released. So that's very important. And when we get to, we're going to talk a little bit about FOIA, but I think it's important for people to understand that if they're asking you to review 8 hours of tape, you actually have to review 8 hours of tape. So they will have to pay for 8 hours of your time to review that tape. And so that's when, FOIA, for those of you who attended the FOIA presentation, that might be where it's a good idea to ask for a deposit to put the person on notice that, hey, you've asked for all of our, video surveillance for one day. This is how much it's going to cost. They may choose to narrow it down, but it's very critical that you do that step. If it does not involve library records, it should be processed as a regular FOIA request. So, and that's not to say that if it involves library records, we don't deal with FOIA issues, because we will deal with FOIA issues and maybe cite some exemptions. But clearly, if it's not a library record, then the other issues are not going to, the other exemptions of the Library Privacy Act, or the other ways in which libraries are permitted to obtain these library records outside of a court order process, then, that's a separate situation we're going to talk about in depth. But again, if it's not a library record, deal with it under your FOIA policy. If someone's asked for, personnel records for, 3 of your employees, that's going to be an issue under FOIA. You're going to have to respond accordingly. And there may be other exemptions, but it's not going to deal with library privacy and confidentiality issues. So if the library records are involved, the library should have a policy to determine whether records can be disclosed and under what condition. We recommend that every library have a confidentiality policy, patrons on notice of the library's rights and responsibilities with respect to their policies. Unlike FOIA, which requires you to have a policy, the Library Privacy Act does not require a policy, but we think it's a good idea so that everybody's on board and everybody understands, and their client-facing policies, so that patrons will see the policy and say, okay, this is why when I came into the library and got in a fist fight in the new book section with another patron, and I wasn't holding any book, or, the audio wasn't captured, that you could just give that out under FOIA or voluntarily give it out because it was not a library record. Here's where it shows that's on notice of that. Typically, too, the policy, we recommend that you delegate or state in the policy who has sort of the final determination of what is a library record, because, obviously it's got a legal definition. You want to make sure that, not everybody at the library is going to be in charge of reviewing videotape and looking for library records. It should be a centralized decision. Typically, either the director, who is the FOIA coordinator for public libraries, or the library's designee should be the one to go through and determine whether something's a record or not. Again, and then we give the example of surveillance video tape really should not be released without the consent of the director, at least, or someone who's the designee of the director who's trained in these issues to go through and understand whether it involves library records. So again, we stated that a library record is not subject to disclosure under the Freedom of Information Act. And the library should have a policy, and part of this confidentiality policy is going to deal with the Freedom of Information Act. Typically, the policies will deal with different types of court orders, different types of requests for records. One of them will be the Freedom of Information Act. And then it'll be processed according to your Freedom of Information Act policy. But even if, so this is if you have a record that's a library record. So let's give an example. Someone has requested, they want to know what Jane Doe checked out at your library on July 8th. I saw Jane Doe at the library. I saw a book. What did Jane Doe check out? Clearly a library record. And if there's a FOIA request submitted for it, the library would deny the request and they would cite subsection 1D, which I've cited here. Subsection 1D is the Freedom of Information Act that allows you to exempt information that's exempt by statute, and the Library Privacy Act is the statute. Other statutes apply to libraries under FOIA, for example, Social Security Privacy Act says you can't give out Social Security numbers. HIPAA, there's laws about medical information. There's other statutes that may come into play, but for libraries, really the Library Privacy Act is a big one when you're talking about patron records. So we've kind of dealt with under FOIA what would happen if it is not a library record, then it's dealt with under just processed as a regular record request under FOIA. If it is a library record and it's a FOIA request, it's also processed under FOIA, but it's denied as exempt under FOIA. So we've done sort of the FOIA part of the analysis here. There were amendments passed in 2020, and I know a lot of the library community was really involved in these amendments and what are appropriate situations in which the library can give out records. I want to step back because prior to these amendments, really there were two situations in which a library could give out library records that are defined as library records under FOIA. One is written consent. We're going to get into that because that's still in the statute. And the other was by a court order. And I think, several years ago, libraries said there were things libraries were doing, frankly, and things that libraries wanted to do that seemed that would be permitted inside the public policy of the Library Privacy Act. And you can see the public policy, and it goes back to some case law. There's a very famous case out of Colorado it was about a bookstore, the tattered cover. And the premise of that case, and really the foundation of the Library Privacy Act, is that the law enforcement wanted to uncover records from a bookstore because they had come across, I think it was a meth lab or some sort of drug operation. And they found books that were titled something like, "So You Want to Build a Meth Lab?" In this meth lab, there were books there about how to do the meth lab. And so the law enforcement wanted to find out who purchased the books so they could connect the dots and say, look, obviously, yes, meth labs are dummies. That's a good one. Yeah. And so they obviously wanted to connect the dots to say, look, I think, the owner of this cabin is Joe Smith. And if Joe Smith purchased these books from the tattered cover, then they must be, he must understand he must be running this lab. And so the idea is, based on this, you can see, is that I should be able to walk into a library and read a book about anything. And it's not going to cause the law enforcement to think I have committed a crime because I want to read about how to do a meth lab, or I want to read about ISIS, or I want to read about a very controversial topic. You should be able to have that intellectual freedom to do that without the repercussions. So if we think about that, that's the purpose of the Library Privacy Act. But I would say that in my experience, 90% of requests for records have nothing to do with that. They all have to do with other issues that I'll get into some examples. And so I think with these amendments, I'm stepping a little bit off tangent, but it's important to understand the amendments, I think, were done to say, look, the spirit of the Library Privacy Act was to prevent people from interfering with your intellectual freedom. But there are circumstances in which the library needs to operate, or there's security situations in which it's important that we be able to reveal certain information to protect library property, to protect security that aren't really implicated. The core of the Library Privacy Act is not, this intellectual freedom is not really implicated. And so we recommend that you have a policy in place that covers all these different scenarios of where you can release library records now after 2020 that you may have not been able to before. And I think a lot of a lot of library policies are still, I think, haven't been amended since 2020 and are kind of old and don't have these new things in there. Like I said, I don't think that will prevent you from being able to take advantage of these new statutory exemptions, but I think it's important that your policies come into compliance with the new statute and so that patrons are on notice of instances and where their information may be revealed. I do want to talk about this because they have included a definition of employee or agent. Most of these new exemptions allow an employee or an agent of the library to disclose. So an employee or an agent, and just so when you see those words, I wanted to put the definition up front so you can see what it means. An employee of the library, obviously, a member of the governing body. So your board is just as beholden to library privacy as the employees are. And that's really another thing too, as far as board training. I don't know how many board members we have on here, but it's really important to understand that, because I think that people that are working on day-to-day operations are very sensitive to library privacy. But there are instances in which I think board members might not really understand, especially if they hear something, about a neighbor or somebody else, they might want to say something to their spouse or significant other. And so it's very important that board members also be trained on Library Privacy Act. An individual who's specifically designated as a volunteer and who's acting solely on behalf of the library. This is really important because typically when you have volunteers, volunteers should be trained on library privacy because they are included in the circle of people who have to maintain library privacy. And typically they are asked to sign something that says that they understand that. And as volunteer, they're not going to waive the Library Privacy Act, library privacy. Very important to understand the distinction here between other volunteers. So this does not apply to people who are volunteering as a member of the Friends of the Library. So if you have, you have a bookstore in your library, or you have Friends of the Library that volunteer, if they're volunteering as a board member or a member of the Friends and not specifically for the library, this is something that I think really should be made clear, because you should not be giving private information to those Friends of the Library or other volunteers. You should not be giving that to them. This comes up, and I really want to stress it when you're talking about a millage campaign, because sometimes the Friends of the Library also act as members of a ballot question committee to help promote an election. And I don't want there to be any confusion about whether you can give patron database information to the Friends members for the purpose of a millage campaign. You cannot. They are not acting on behalf of the library. They're not solely volunteers on behalf of the library. So be very careful when you talk about a volunteer program from a Library Privacy Act perspective, to be very clear that they're acting solely on behalf of the library and they're not volunteers for another organization like the Friends. Also, the agent, any person who is lawfully performing services on behalf of the library under a written contract. So very careful, written contract, make sure that if you're going to give information out. Collection agencies are very good examples of that. But we also recommend that, in that contract, you would specifically address library privacy and say, you are acting as an agent of the library under a written contract for the terms of the Library Privacy Act, but you cannot then further disclose this information to other people outside of that scope. So again, it's training of people who may not be understanding exactly, what the Library Privacy Act may not be trained. So that's something that we certainly should make sure that that it's included in the contract, or at least you have the discussion with these contracted entities about their obligations under the Library Privacy Act. Because if they're included as an agent, they can also be held responsible for violations. And so it's really imperative that they understand what the rules are. So disclosure is permitted with a court order. Okay, this is something that is not new. This is one of the things. This is one of those things that would be very important for, if you receive a court order, before, like I said, you basically could give it out only if they consented to it or if there was a court order. What is a court order? I think we used to be very conservative about this and say it had to be a search warrant, which is it's been reviewed by a judge. But now, based on our understanding of the term court order and how it's used in Michigan court rules and how it's used in Michigan laws, it also can be a subpoena. So if you, as a director, or if you're an employee, the first thing to do is to make sure that subpoena or that court order gets to basically the highest person in command. Ideally, the director. If the director's not there, the director should have a designee of who deals with that, because there's certain things that can happen depending on what type of court order it is. So basically notifying the director immediately upon receiving the court order. We're going to get into other types of orders later that are more specific to Patriot Act and or immigration enforcement. But typically they're subpoenas or search warrants, or they're subpoena-like or search warrant-like. So once you get a court order, the director or the designee or board president will decide how to respond. Again, it should be a very high-level discussion. You shouldn't leave it up to the newest person at the circulation desk to be determining how to deal with a court order. So your staff should be trained on library privacy. And the one thing is, like, get the document to the right person. Under the Library Privacy Act, the library has an opportunity for a hearing and maybe represented by counsel. And this is nice in theory, but you might have a situation in which you receive, let's take the situation in which you receive a subpoena, okay? A subpoena is something that's not immediately executable, meaning that it's a request for documents, it is a proper court order, but it will say, the library has to produce X documents by a certain date, okay? If you receive a subpoena, you will have time. You will have time for attorney review. You will have time to potentially get a hearing in place. Where we have done this, and I'll give you a couple examples. We have received some subpoenas from law enforcement where the library really wants the subpoena. There's a crime that's been committed. There's a library record at issue. It's a sign-up sheet for, let's say someone's looking at very serious situations. Someone's looking at child pornography on your computer, and you know who it is. There's a sign-up sheet that shows the computer, that shows the time. You want the police to have that. You would still request the court order, potentially, and then if they gave you the court order, likely you wouldn't want the hearing. The times that we've addressed the hearing, and I've been doing this for a long time, and I have yet to actually go to a hearing. Sometimes we have told the person that we will not respond until there's a hearing. So, for example, they have asked for a lot of documents where they want the library to be involved in a child custody issue. And libraries are, even this week, I'm hearing stories about how libraries have been meeting places for these supervised visits for children. And sometimes the library has been asked to really get involved and give over tons of records to, because they're caught in the middle of a domestic situation. And we'll say to the person, and a lot of times it looks like they're on a fishing expedition, hey, we're going to ask for this hearing to maybe lower the scope or reduce the scope, or see if this is really necessary, because this is going to take 40 hours of our director to go through all this stuff. And the times that we've done that, the person's actually withdrawn the subpoena. So it may be a way that you can, maybe either narrow the scope or avoid having to deal with the subpoena altogether. And one of the questions is, if the director or designee is not present, is there a time limit? Is there a type of order that's immediate? Yes, there is, and we'll get into that. That's a search warrant. So if it's a subpoena, the first thing you're going to do is look at the date of the subpoena and determine whether they whether it's, you know, what the date is, when it's due. And one of the things that we've done too is, and we've updated it in light of things, but we have a policy. So we have a confidentiality policy. We also have we recommend having a set of procedures for the library. So like there's the overall policy, like you shouldn't give out documents to a court or, you know, in response to a subpoena until you reviewed it, you know, with the lawyer and talked to the director. The policy or the real procedures should be, what is the step? Because you really want, especially if you've got, you know, you guys are open on not 9 to 5 hours, and, you know, sometimes the director can't always be there, obviously. And so you want staff to really understand, okay, what do we do? Like it's just sort of a decision tree. And so that's really effective to have those types of procedures in place in addition to the policy. But like step one of the procedure is look at the document and when is it due? Okay. And do you have time? Do you have time to call the lawyer? Do you have time to have the actual director? If the director's, you know, if the subpoena says it's, you know, documents are due in 2 weeks and your director's on vacation for a couple of days, it's fine to wait. And we'll get to where a situation where it might not be. And that's with the search warrant. A search warrant is immediately executable, meaning that you know, the police can knock on the library's door or walk in the library and hand you the search warrant and say, you know, you can ask for, hey, can we have our lawyer look at it, or you know, can we have time to review it? They could, as a courtesy, do that, but they don't have to if it's a true search warrant. So again, a process or procedure should be like, what do you look for? Look for things like, does it have, you know, the right court information on? Is it signed by a judge? Is it dated? You know, there's things that you should look for that should be in the procedures, because that might be a very acute situation where, you know, it could be very stressful. So you want people to be prepared in what they're looking for, because that is immediately executable. Really, when in doubt, you know, and each of you should talk to your own lawyer about this, but my typical recommendation is that when in doubt, if it looks on its face to be fine, if it's signed, let the law enforcement do what they're going to do. Make sure you take notes, make sure you understand what they're taking, all of that. But it's a better position for the library and their employees to be in than to be in a position where you're violating the court order or interfering with an investigation. Again, that's something that I really would have you discuss with your own lawyer, and they may give you more nuanced opinions on that, but that's just generally my train of thought. Some court orders might have a gag order on them, and this is one of the things that it was prevalent with Patriot Act search warrants, where or the equivalent of a search warrant from Patriot Act where it had a gag order attached to it, meaning that it was very limited on who you can talk to about it. So if you get something with a gag order, make sure you understand what you can do. Can you tell anybody? Can you get your lawyer involved? Who can you tell? That's something that's going to be important. I haven't really seen that recently. Maybe some of you have experience with that, but that's something we were very worried about. I think when Patriot Act really was, you know, first came into being and first really affected libraries, but I haven't really had a lot of experience with that in any recent years. Not that I could tell you under gag order, but I guess I can tell you the negative. So now that we've discovered that we've covered court orders, and that was again something that was permitted under what I call the old version of the Library Privacy Act. The other one was consent. The other way you can give out is if the person consents to it. This is mainly done, and what they have to do is that they have to be responsible. And this is the way it's written, and it's kind of strange, and it's really geared towards children. But you can waive and give permission for the person to have your records if the person will become responsible for the payment or return of the material. And so you can see where the parent-child situation is with that, is that, you know, technically you can't give out a child's record to a parent unless they've agreed in writing to accept responsibility of the payment or return of materials. This is it should be, it should be in place also with spouses. And I know some of this, I think, is is very difficult because a lot of this interferes with what we consider, and I know what libraries consider good service. So you might set books aside and you put the person's name on it and allow anyone to pick up the books. And that's, it probably is not resulted in any problems, but, think of a situation in which, I offer worst case scenario. Let's say there's a spouse that is thinking about divorce and she's afraid of the spouse. And if there's books aside about divorce or dealing with trauma, and the husband comes in or the wife comes in and sees that and has access to that, that's where it becomes a problem. Again, as lawyers, we deal with the small percentage chance that can happen, but that's why we really recommend that you don't give out any information unless you have that written permission from the person that they're responsible for return or payment. The strange thing about that is that it actually doesn't say that. So if they're my library records, it doesn't say that I also have to give permission for the person to be responsible for the payment or return. So it's strangely enough, as written, a third party could come in and say, "Oh, I want to accept I want to accept responsibility and payment for Anne Seurynck's material." Now, as a matter of library policy, I would recommend that you have the person who's actually the account holder also agree to that. Otherwise, you could see how it could go very badly if that's the situation. But that's actually how it's written. So I just want to raise that issue with you. So it also has to be written consent, and the procedure form of the consent is determined by the library, and that's where you can say, I give this person, this person's, you can give, within the card application. That's really where we're seeing it now, is in that application process. Make sure that it's done, if it's done electronically, that it's done in a way where that's a valid, contract or a valid written consent, and it must be in writing. And I give a very unpopular opinion about one thing, and that is programming and pictures of programming. And I get a question it's a constant question I've gotten over the years is, well, we don't make people, we have a cute children's program. Okay, we're going to have someone coming in singing song. We have a cute children's program. We have a sign out front that says, if you're attending the program, you give permission for your child to be filmed and used on social media. Is that sign a proper written waiver under the Library Privacy Act? In my opinion, it's not, because the people have not consented to something. And there has been situations where this has become a problem, where there's a lot of people, and I talk about this with a lot of library groups. There's a lot of parents out there that are very, very protective of their children specifically, and their children's appearance on social media. And if you put a picture of a child on social media, a lot of, you might have parents that are like so excited to see their kid at a summer reading program on your, Instagram, and they're all excited. But there are parents that are going to be upset about that, and that has happened, where libraries have, been in situations where they posted pictures on the internet that have not been received well from parents. So it's a real issue, and so I would be very careful about that, and not just having the posting of the posting as sufficient, because it's not going to be technically under the Library Privacy Act. But you can have a sign-up sheet, and the sign-up sheet can have that on there. And if you say the sign-up sheet that shows that everybody consented to that, that's another way to do it. The other way that we do it is not showing faces. So maybe blurring out or just showing the back of the head if you can't identify the child. you can just get taps of the back of the head. The other way we've done it, if we want like a good social media, is that we've had like, if we have like someone that wants to show your computer room, we have our employees sit in and act as like actors, so they can get the good shot. So that's something that that can be done as well. So I see there's some there's some comments in the chat. I think I'm going to take those at the end and we can go through them, and then anybody who wants to stay can go through those on the chat, and we can run through those pretty quickly. But I just want to get through the slides because I think we're running a little short on time. Disclosure is also permitted. This is a new one. A library employee or agent may report information about a delinquent account of a patron to a collection agency under contract with the library. So you can only provide the information necessary for the return of overdue or stolen materials or to collect fines. So libraries were doing this before. They were sending all their patron information to collection agencies, and technically that was probably a violation of the Library Privacy Act, but it was something we needed to do. And this is one of those situations in which the legislature has the situation in which the collection agencies were doing the good for the library and in fiduciary obligation of collecting information. So again, that's something that is really important. And I do want to stop and do one chat, because I noticed one that there was a chat about our city lawyers giving opposing about photos in the library have said that the public space, they don't have the right to privacy in the library and the program. So what do we do then? I look at this from a different lens. And if you are getting guidance from your city attorney, I understand what they're saying, because when we talk about this in the context of First Amendment orders. So if I walk into a library and I'm a patron, I'm going to see people with all sorts of books. I'm going to see people reading. I'm going to see faces. I'm going to see people in attendance. So you're right, there's no general sort of right to privacy. The problem is when a library takes a picture of a patron and uses it for library purposes, that physical document becomes a quote unquote library record under the Library Privacy Act. So that is a situation in which if the library released that on social media, I think that's a problem. Now, if a patron takes a picture of another patron and posts that patron's picture on the social media of that individual person, that's nothing the library can control because of this very reason. So what we're talking about here is the library's capturing of information and what I consider a library record, and using that library record. And that's where I think it's different and slightly nuanced. So I hope that explains that. And that's something, certainly if people have conversations, I can have conversations after that to explain that more. If there's follow-up questions, I'm happy to answer those, but that's where I see the difference in that. Interlibrary loans. The library, an agent may disclose library records to another library for the purpose of conducting interlibrary loans. The library records must be limited to those required for providing interlibrary loans. So another area where, like over the years, I'm like, oh, this is not good, because libraries were sharing information about patrons for the purpose of interlibrary loans, right? It's at the heart of Library Privacy Act is, what is this patron reading? What books are they checking out? Okay, so it was sort of one of those like kind of legally troubling things that we just, I don't know how you get around. You couldn't have interlibrary loans without that problem. So this is what is now you can disclose. And I want to say may, because some of these exemptions they give the library the decision whether to do it or not. You don't have to. It doesn't say the library shall disclose. It says that you can without a court. You can still say, I want a court order, for example. We'll get to law enforcement, but it allows the library, it puts the control in the library's hand to voluntarily disclose this. What does this not do? This does not allow a library to share information about another patron with another library. And I know it. I guess I don't know it, but I can see a situation in which you might have especially you live in a larger metropolitan area where you have a number of different library systems and you have a particular problem patron that may be very concerning to the library from a safety perspective or otherwise. But this specifically does not allow you to share information about patrons with other libraries that doesn't specifically involve interlibrary loan. So it's just a little bit of a heads up on that. Law enforcement. This is the one that I think prompted a lot of the discussion about amendments to the Library Privacy Act. Okay. So the section does not prohibit an employee or agent of the library from providing a sworn statement or testimony to a law enforcement officer based solely on personal knowledge regarding a crime to have occurred in the library. So a situation in which you can disclose to the library, disclose to law enforcement, you can describe events that happen in the library if it's based solely on your personal knowledge. This is one of those things that I'd also like you to talk to your attorney about, because it does get into a little bit of gray area. What is your personal knowledge? Meaning, do you know a patron's who they are because they're your neighbor that happens to be a patron of the library, but you've lived next door to them for 15 years, so they know who you are? Or do you know them because you've looked in the database and know who they are? So I'll give you kind of a strange example. And my sister is a library director, and I asked her for some years ago, I asked her for, some incidents that happen in the library, just generally, that cause problems. And, she described the people fist fighting over the new book. Okay. So you have two people fist fighting, getting a fist fight over a new book. Okay. Crime, assault occurred in the library. And so the personal knowledge, and the people because you just know who they are. You know them from other places. You may know them by name. So that's a verbal testimony. If the person hears of the cops coming, runs out of the library, goes through self-checkout, checks out the new book, and that the only way you know the person now is because of that library record, that's where the personal knowledge is not going to be in play. So again, probably before you talk to law enforcement and give out information about a patron, I'd contact your own lawyer and talk about the risks of, how do you know this person? Is it really personal knowledge? The other factor is that a crime, it has to be a crime, which is, we'll get to the, I'll talk to you about what law enforcement and crime are, but it has to have occurred in the library. So this is, this is not something you can voluntarily talk about if police come in and it involves a patron, but it doesn't involve something that occurred in the library, that's where you also may not get this exemption. So a law enforcement officer means an individual licensed under the Michigan Commission on Law Enforcement Standards. So, your sheriff's department, local police, state police, these are all going to be a law enforcement officer. A crime is defined under Michigan state law, and really here's what it is. It's not a civil infraction. So if someone hasn't mowed their lawn and it's a civil infraction in your city, it wouldn't qualify, and this puts a lot of pressure on the library staff to know what's a crime or what's not a crime. Again, it's permissive. So if there's any doubt, say, look, I may be willing to provide a statement, but I got to check with the director and we got to make sure the exemption applies. And then it's not mandatory, it's not immediate. So that's really important to understand. If a library or an agent or employee of the library violates Section 3, the library is subject to liability to the person identified in the library record that's improperly released and disclosed. The person identified in the record may bring a civil action against the library, whichever is greater, and a court might also grant equitable relief. Something you might not pick up. This is an amendment that was a very, very important amendment in my personal opinion, because what this is unintentional violation. So this is like, you give out a library record, you didn't realize it. Let's say you gave, there's two Joe Smiths in your town and you gave it to the wrong Joe Smith. And now they, published on Facebook all the books the other Joe Smith is reading. Innocent mistake, unintentional violation. Prior to the amendment, the statute read that the employee or agent was the responsible for the, like, so that basically you are on the hook as an employee for that violation. And we thought that was something that was completely unfair. That's a lot of pressure on the library. The only time that helped was when we were getting what I thought was undue pushback from law enforcement, and we'd be able to say, hey, if you demand this from the staff member and it turns out to be that they can't release it without a court order and you not want to get a court order, that person might be like on the hook personally. Do you really want to do that to the library director? And so sometimes that was a way to kind of have law enforcement back off, but those were few and far between. And I think the amendment to this is excellent. I'm going to knock on some wood here. There's not been, I'm aware of, and if Claire's on, I don't know if Claire's here, but Claire can chime in if she's heard of anything, but I'm not aware of, and if anybody has had a lawsuit filed under the Library Privacy Act, let me know, because so far we have not heard of one. I have not personally heard of one. The thing is what I tell, so risk is something, again, you should talk to your lawyer about, because I will say there are cases sometimes with exigent circumstances. There have been cases where libraries have been contacted by police about locating a lost child. There's been cases where safety and security of library staff may be at issue, where you're talking about calculated risks, and that's something you should certainly have with your attorney before that. So even absent those circumstances, like I said, most of the Library Privacy Act issues come up with crimes that have occurred in the library, and the library has an interest in preventing. Obviously, you want it as safe environment as you can. You don't want crime in the library. It's important to understand that, unlike other waivers, the library does not have the right to waive privacy of a third party. And I give my Law and Order scenario, which is that, everyone who's seen Law and Order or crime shows that the police go into a bank or another private place and say, give me your records. If you don't give me your records, we're going to shut you down. And they always turn the screen and, or walk away and allow the police to look at the records. Private businesses have different, I'm not speaking for all of them. There might be some regulations, but most private businesses have rights that, if it's their property, they might have the right to turn that over. You as a public library don't have that right. It's not your privacy right. It's your patron's right. And I'm always worried that, like any evidence that's not properly, if you give out library privacy rights without the proper procedures in place, if you give out library privacy or library records without the proper procedures in place, then there might be an argument for a defense attorney that was improperly obtained evidence and the person might not be convicted. Now, that's not your problem, that's law enforcement's problem. But again, if you're trying to protect, the safety and security of your library, you want to make sure that, one, you don't violate the Library Privacy Act, and two, that you don't give it out to anybody that may have committed a crime in your library. Intentional disclosure, the employee or the agent can be held responsible for intentional disclosure. And it's $250. That's another thing. I had a police officer once say, well, I'll give you the $250. And it's not just $250, it's actual damages, including reasonable attorney's fees. And litigation can be expensive. And so if you are wrong or if you've done it inappropriately, you may be on the hook for that person's attorney's fees as well, which are likely going to be, far in excess of the $250. So a civil action has to be brought within 180 days after the person first knows about it. So this is actually very good, especially if there's unintentional violations. It prevents library employees from being dragged into lawsuits even maybe years or after they were initially it happened or they were even employed at the library. So I want to spend a couple minutes now talking about specific enforcement issues, because I think that's important to be prepared for that. Again, I mentioned before, I won't spend a lot of time on this, that you should have an enforcement procedure in addition to your policy that really dictates, who's in the chain of command, who do you need to contact. Because of the ICE warrants that go out, the library should also clearly mark available that and places that are not available to public. And I say this from a patron perspective and from a privacy enforcement perspective, because we've had patrons wander into, private areas of the library, the director's office. And if they're not clearly marked, you want to make sure they're clearly marked for this reason and for enforcement. So patrons have to stay in the public area, and it should be part of your policy. But that's an important part to think of if you haven't made it very clear where the enforcement lies. So enforcement procedure, I've talked to these issues briefly, but the director should be notified, and then who else should be notified. Your procedure should really say, do you know who your computer consultants are? Know who's in charge? Know what board members should be contacted? Know how your records are kept. This is an important part because you have to know if you have access to the record. So if someone comes in with a search warrant and says, I need all your patron information from 2 decades ago, and it's not on site, or you need a computer technician, it is very important to work with the law enforcement at the front saying, this is how they're kept, this is the vendor. You also should be able to make sure that you understand how to keep records. If you're waiting for a search warrant and your computers reboot every night, you have to make sure you are able to preserve that evidence. So also important is knowing what your record retention policy is, because right now there's a very short retention policy for video surveillance. And so if someone would come in with a search warrant, or you'd have to check to make sure, but you could say generally, you're asking for video surveillance from November of 24. We only keep it for 7 days, 30 days, and so it's really important to know not only who has that information, but how long it's kept and where it is kept. So again, I mentioned before, know how to preserve evidence. And if you're anticipating a search warrant, because the police might come and talk to you and say, okay, a warrant is coming. At that point, you should stop and to the best of your ability, preserve the evidence that they're looking for. If you believe or have a reasonable belief that there's going to be a search warrant or other requests, then that should be done. Police involvement. Okay, so this is very procedure. It's not policy. We're talking big picture before, but ask for identification if you're not familiar with them. If there's a local police department that is next door to the library and they show up, fine. But if it's the FBI or the sheriff's department or state police that you're not familiar with, make sure that you know who they are and you're familiar with them. Verbal requests. There's no responsibility to respond to verbal requests. Okay. And so it's only the written request. But again, if they verbally ask for information and you anticipate, they're going to be a search warrant, and it's not unreasonable to say upon verbal request, hey, you can submit a search warrant, but I just want you to know you've asked for video, 6 months ago. We don't have that. We don't typically keep that video, but if you get a court order, we'll look for it. But that's, it's okay to talk to them about that. But again, you don't have the right to consent to the release of library records without a written request. So that you should be really careful of that when you talk about verbal consent. Now, there's issues if it's not a library record. There's FOIA issues about verbal requests and stuff. So we're really talking about here library records under defined terms. So make sure that if it falls under that category, you don't respond to verbal requests. So again, what if you get a court order? Immediately request that the library be allowed to send to the library attorney. And we've already talked about this, but review it to your best of the ability. If you don't have time, again, observe what the officer is seizing, keep notes, keep track of costs, and request copies or itemize a list of everything taken. It's very important to know exactly what they've taken, and so that you get your property back, and make sure that you are involved in that. So I've given sort of a step-by-step, some of the text is, I mean, you can have copies of these slides, so, but police involvement with a subpoena, and subpoena is what I talked to you about before, which is not immediately executable. It's documents to be provided by court order, but you're given time. Determine the date, as I mentioned before, whether library records are being requested. Then, we typically recommend you contact the board president and the library attorney. You do have that right of the hearing, but that's something that you should discuss with your attorney and your board, and your board president. That should be one of the things that if you decide not to comply, then there should be the hearing or a motion to quash. And then if you decide to comply, then that's where you might have your attorney involved with working out the logistics of the subpoena. Search warrant is a little bit different, as I mentioned. It's immediately executable. You can request that, the library attorney see it, but they don't have to grant that request. I've given you a few things to really look for. If you don't have the opportunity for legal review, make sure it's signed by a judge. The warrant's dated, includes the name of the library, the employee, it has not expired, and review the scope to ensure that only the areas or items identifying the warrant are being searched. So again, that's sort of the due diligence if you don't have the time to get a lawyer involved in that. So again, I think this is a similar process for the search warrant, just more of a different order here, but obviously notifying the board president and so forth and keeping that list. I want to talk a little bit about certain acts, the Patriot Act, because you really have to kind of follow I talked about the subpoena process and the search warrant process. So when you get a Patriot Act, you follow the procedure for search warrants, because this is the Patriot Act. Subpoenas or the documents are more like a search warrant than a subpoena. Again, so you may not be able to get lawyers involved, but again, going back to that earlier slide, make sure that you understand the scope, that they adhere to the scope, that it's signed, all those things to make sure just the base level of what you can do reasonably as a library employee, not, who doesn't, may not be trained in law enforcement to know exactly what it is, but just do your best to see if the information is there. I don't have copies of some of these documents, but they're available and we can certainly provide those. But I've also amended our procedures to deal with police involvement from ICE. Some of ICE involvement involves your employees, documented employees. And so if that's the case, contact your lawyer and your employment attorney about that, because what I'm talking about here only applies to patrons. I think there's a fear, especially if you have a population of like a high population of immigrants. I think people are worried that the ICE is going to come into public spaces. If there's a request by ICE agent for library records pursuant to a subpoena or an ICE administrative warrant, and there's two different forms, and we can provide copies of what they look like, so you're prepared. But you should follow the same procedures as you would for a subpoena, because those aren't immediately executable. But if there's a judicial warrant, which is signed by a judge, follow the same procedures as you would with a search warrant. ICE agents are permitted to come into public and not private areas for the enforcement of immigration without the judicial warrant. The judicial warrant is more like the search warrant, and that would only be permitted in private areas if the warrant permits them to do that. So if they just come in and they don't have any documentation, you are not required to allow them to go into private areas. If an ICE agent enters the library and demands immediate access based on statutory authority or proper search warrant, I know that a lot of people have a lot of personal feelings about immigration right now, and my rule of thumb is you talk to your lawyer in advance of this, but if they have a proper search warrant, or, if the library's role is not to protect its patrons from immigration enforcement, even if ICE is wrong, that's really not the library's role. And so I really would talk to your lawyer, but I would caution about jumping in and, interfering with something if you feel that's something that the law enforcement should be called if you don't think things are being done. But library employees should really not put themselves in a position where they are could be potentially interfering with a federal enforcement action. Now, that's something that that's my recommendation. That might not be your lawyer's recommendation, as you've seen in the chat. Lawyers, have differences of opinion, and clients may have different risk levels. So this is a webinar. So, I'm not telling you what to do or not to do, as my, but I think this is something you should have a conversation with your lawyer about the risks, because I just would be very careful about putting yourself in a situation where you're could be in a position where you're in a position where you're interfering with a lawful federal enforcement action. Oh, questions. Okay, sorry, I'm running over a little bit, and I appreciate your patience. I'm going to try to run through the questions. So obviously, if you can't stay, let's see. How would one track the unique number of individuals coming to the library is given? I don't, Laura. I don't. I did a little bit more information on that. I don't. I guess I don't. We can talk offline, because I don't understand what the unique number is, maybe. Would this be relevant for programmers or program registration lists, for example, register listed names, people, NJ? Yeah, I think, typically your programmers should be under contract. I mean, I think even a simple contract, and even if the contract's that, they're an agent for the purpose of the Library Privacy Act and no other reason. I mean, you want to be very careful about how those contracts are written. If the person obtains the information themselves and not through the library, that's also a different issue. So if the yoga studio collects the names and they're just basically using your space and they're not really library records, that almost may impact it. So that's something I would talk to your lawyer about, whether that's something that should be in the contract or explained, or, that maybe the programmer never has that information, or if it's completely their property, that's where the difference in the Library Privacy Act. And that could be that, if a programmer takes a picture and it's not a library record and uses that picture, that's really the programmer's problem. But that's something that may be subject of a contract, or certainly something that you want to discuss with the programmer or your lawyer about that. Is there a derelict is not present? Oh, I think I answered Suzanne's question during that time. Link QR code to a library app with spouse considered consent or an association with a patron's account. It would have to be technically under Library Privacy Act. You have to accept responsibility for the payment or return of materials. So if it's not that, technically it's not a proper waiver under the Library Privacy Act. Now, you can discuss with your own lawyer. I don't want to discuss it. That's a private conversation for your lawyer about risks. If the risks that someone would sue if they've given permission, for example, even if it's not the right words are used, that might be something. But I would have a conversation about that with your lawyer, just to make sure that they're okay with that from a library privacy perspective. Is there any part of disclosure section that would mean that having full names on hold slips for patrons would be an issue? From a library privacy perspective, I do not like hold slips that have the person's name on them, because I think that's I think that's a potential library privacy violation. Again, libraries have been doing this for decades and nobody's complained, but I certainly think that even showing that the person has checked out books, if you can do a code, your last 4 digits of a phone number or something like that, where it's not immediately identifiable, that would be the better practice. Books and file until we move it. So we can designate people that are allowed to pick up our books and have it on file until we move it, or one time for all. Yeah, the library can dictate how it wants to deal with its library privacy waivers. So that would be dependent on the library, on the library. One of the things just to consider is that, sometimes libraries want to have a natural time that that their card expires so that they can redo material, make sure the address is still correct. If a person has been divorced, maybe a child is 18 now and doesn't want to be on his parents' account or doesn't want his parents to read what book he's reading. I mean, those are sort of the natural things of that, it's really in the discretion of the library how to obtain that waiver and how long you want to keep it in effect, though. I think I answered Rebecca's question here. If we include a statement about a photo or electronic registration in our program is sufficient, our electronic registration page. If they sign something that agrees to that waiver, then that's my opinion is have they signed something that officially, and I have school age children, and I know that and every time I sign them up or re-register them from school, there's a universal waiver that's in that, in my yearly registration material. So that could be something you can do too. It's hard to kind of keep track of those. So as long as the sign-up sheet also constitutes a waiver and your attorney's okay with how that's done, then that's fine. But if the waiver is, to me, it has to use those words. It's strange, but that's, or, a photography waiver. You can have a specific, I think, photography waiver which is fine as long as they really know and what they're understanding and that they sign that and that if your attorney's okay with the format and the way it's worded, I'm fine with that. Yeah, it's a lot of info. It will be available to be reviewed. What's the library's liability if a contracted service provider, such as where they sell patrons in order to make the party? Again, there hasn't been a lawsuit under Library Privacy Act, so I don't really know how this would go out, but I would say that it says an employee or agent. And if they're an agent, I think they have their own responsibility not to reveal that information. So I would include it in contracts, but I also think that's the position I would take on behalf of the library. If I was defending the library, I'd say, look, if a library or agent of the library discloses that a library didn't disclose it improperly, the agent of the library did. So what the liability is, I don't know, because we've never had a lawsuit under it to see how that would pan out, but it's interesting. Yes, we do have law enforcement procedures if anyone wants to talk to me about that after that. We offer, our firm offers model policies. We charge a flat rate for those, both the confidentiality and the law enforcement procedure. So if that's something you're interested in, certainly reach out. If staff calls the police due to a crime in progress, the perpetrator, please do what information can be disclosed? Can the names be given at that time? Can the description given? So that's like an example I gave before using that fist fight scenario. I think something that I think a lot more can be shared now than can be shared before. Certainly any observation of the library staff. The person was there, they were wearing a red hat. They were arguing with another patron. The person in the red hat threw the punch. The patron in the blue hat did not throw a punch. Those are the kind of details you certainly can. The issue about identity and can you get the address out, that's where you're going to have to decide whether it's based on your own personal knowledge or knowledge from the library. And that's where I mentioned that you might want to get your lawyer involved in that part of it. And so with the discussion with the police, you could say, look, here's what happened. I have to review the issue with my lawyer to find out if I can give you any name and contact information, and I'll get right back to you. That's how that would play out, absent a search warrant or a subpoena. Will the search warrant include a word judge somewhere in the signature, or how do we know the person is signed by a judge? There should be a line that says the judge. It's usually a judge or magistrate, and if it's signed, if it's a search warrant and it's signed, I think that's the best you can do. If someone otherwise they're fraudulently providing you a fraudulent document. And in that case, I think there's a whole different issue of problems, but not really the library's problems. I only say that because I think it was decades ago, I had someone send me a search warrant for a document, and I realized it was like not a valid, it was just a police officer said, well, you said you wanted a piece of paper, here's a piece of paper. And most of the search warrants we come in look a little suspicious because a lot of them are child custody issues. So they have a lot of very they don't really give a lot of detail or the names. So again, that's something that I would have your lawyer look at. If law enforcement comes and shows a picture and asks if we've seen them, they don't ask for any patron information. I think that's likely that somebody, it's based on your, this is a little hard because, again, you really have to figure out if they're asking for identification or whether you've seen them, that's something that I would talk to your lawyer about, because I think that's going to be very circumstantial about whether I would recommend someone give out that information. Certainly, if it's about a crime that occurred in the library and you are looking at the person and they ask you, yes. But if it's a crime that didn't occur in the library or they're trying to search for something, that's the part of it that I would be a little bit more curious about what the situation was in order to give a good advice. Let's see, these would all be programmers under contract for use in the library and event space. Yeah, the programmers, you should have a contract. They should have a contract that would, I should have that, your contract should deal with library privacy, I would think. Or you could, that would be something I would recommend including in that contract. Do they have to, let's see, do they have to sign or can they just tick a box on an online registration? Again, it's gonna depend on what they're agreeing to. If the registration just says photographs might be taken, I don't think that's enough. But if the registration says by signing this, you agreed and consent to having your picture used by social media, that's a different question. That's something that language should really be reviewed by. Because once you get a lawyer to look at it, I think you can repeat that language in different signups, but I would have at least initially have your lawyer take a look at that to make sure it's make sure it's properly written, and so that you feel comfortable under the Library Privacy Act. What if it's a missing minor? So I'm just going to come out and say this because my official answer is that you should look under library privacy. You should talk to your lawyer. I have had situations in which libraries have decided that even if it is a Library Privacy Act violation, that the safety and security of issues of what's involved outweighs the risk of a Library Privacy Act violation. So if you have a child that was in the library and they think that child was abducted out of the library and you recognize the child and they were there an hour earlier and you saw them leave with somebody. Okay, first of all, it's a crime that occurred in the library, but even if they were abducted out and then they wandered in and were in the library and a lot of clients would decide, even if there's a technical violation of the Library Privacy Act, that based on, the safety and security issues, that the risk is very low. And so that's just something that from a lawyer's perspective, you have to advise the client of the risk, but then they can decide what the risks are and whether to, the risk of the violation of the Library Privacy Act, which I've just mentioned, no one's ever sued, but I don't want our clients to be the first test case, obviously, but might be outweighed by any, concern for a child that's been abducted, for example. Let's see. When is the recording expected to be emailed out? That is a Jake question. So shortly, I think they've been emailed out very soon. The presentation and the audio's been emailed out. And so if you have board members that might be interested in this, obviously, certainly, please feel free to share. If there's no more questions, then I'm sorry it took an extra 20 minutes, but I appreciate your patience and thank you for all the great questions. And if there's, I think my contact information is on the first slide when you get it. Certainly follow up if there's anything that wasn't clear. All right. Thank you.